Good morning and welcome to our 5-day Manager Return to Work workshop. My name is Scott Cuthbert. I'm CEO and co-founder of Safepedia. And with me is Tamara Parrish. She's our Director of Community Development. We're extremely glad you could be with us today. And we know you'll get some extremely valuable insights from today's industry experts. If you're familiar with Safepedia, you'll know that we do 3 to 4 educational webinars per month, typically on different topics, but given the challenging and uncertain times, we wanted to provide a comprehensive and collaborative look at COVID-19 and how to manage your return to work programs. At Safepedia, our mandate is to harness the collective genius of the health and safety industry. So we're doing things a little differently by streaming these workshops through Facebook Live in our private Facebook group, Safety Movement Makers. So we encourage you to join the group, connect with your peers, post some of the challenges you and your organization might be experiencing, ask questions, and also access these presentations and their supporting materials on demand after the live workshops. This is new for us, as you can probably guess, and so we want to make this the most immersive, collaborative experience possible for our attendees. So any feedback, criticisms, suggestions, ideas are more than welcome, and if you join our private Facebook group, Safety Movement Makers, we'll get all those comments and emails from you to incorporate them into our future presentations. So I know you didn't come today to listen to me talk, so without further delay, I'd like to introduce Kathryn McMahon and Nicholas Scala from Conn, Maciel, Carey law firm. Kathryn and Nicholas are partners with the top OSHA law firm in the country. So without delay, I will turn it over to Nick and Kathryn.
Well, thank you so much, Scott. Thank you very much, especially for that very kind introduction. Nick and I actually do believe we're the top OSHA law firm in the country. Actually, it's very interesting, maybe just exactly the right way to start, because just as by way of very brief background, because we don't want to, you're not on this call to learn about what we do all day long, every day, especially back in the old days in the pre-COVID time. But we have a robust and sort of comprehensive OSHA practice, both enforcement as well as rulemaking and special projects and, the whole gamut. However, since about, what would you say, Nick, probably early March, maybe late February, our practice has really turned into a COVID practice. I don't know that the ABA recognizes that yet as a practice area, but it certainly is what we've been doing almost 24/7, honestly, literally, since this pandemic came to the country. So we're very happy to be here to talk to your group today. Nick and I are so willing to kind of talk about either specific situations you're dealing with at your workplace, or more generally, what we're seeing across the nation. As I said, we've been doing this for about 4 months now, every day, talking to employers in all walks of life, from retail that was closed down, and how, we have an employment group that dealt with a lot of questions related to how do you deal with the people who you were laying off temporarily or permanently, to most of our clients who have been considered essential businesses and have been operating throughout the pandemic. So we've been helping them, guiding them, providing advice as to what the best practices are, what are the legal requirements, etc. So we're happy to talk today, and I think what Nick and I decided to do is, rather than spend the entire time you've got, walking through this 50-odd page slide deck that I think you'll have available during this presentation or shortly after, we thought we'd just sort of start with some general overarching remarks that I hope are insightful and informative to you all who are out there every day dealing with the COVID pandemic in your workplaces, and that are based on essentially lessons learned that we've gathered. This is obviously a brand new thing for everyone in the country. And our OSHA background obviously gives us a sort of a leg up in understanding what the agencies, the regulatory agencies, how they would apply their regulations, both old and new, to this new arena. But you know, every day is a brand new question that we grapple with. And same with the agency, frankly. You know, OSHA on the federal level as well as the states, this is all brand new to them too. So with that, let me just provide a little bit of background, and then I think we'll spend the bulk of our time. Nick and I are gonna kind of tag team here and try to keep this as one, interesting, and two, informal as possible, where you all can jump in and ask us questions. But maybe just by way of brief background, I wanted to share what, you know, I'm sure anyone who watches the 6:30 news, if that's a thing anymore, I'm old enough that I still turn on the 6:30 news and my children are like, what? You know, like I learned that on social media 3 minutes after it happened, you know, so, but I still watch the 6:30 news, and I'm home now working, so I can do that. And so this is nothing new to any of you, but it's worth repeating from my perspective. And that is that, you know, COVID-19 is unfortunately here to stay, at least, hopefully to God, not, you know, forever, but at least for the next phase of our lives, the next couple of years. It's not my expectation that even if we do have a vaccine developed, and there's obviously remarkable work going on in terms of drug protocols for sick patients, I think you as employers are and as health and safety professionals are still going to be dealing for the next few years with the ramifications of the pandemic in the workplace, regardless of what's happening on the health side. So with that sort of landscape, I think one of the things I want to share based on the work that Nick and I have done with our clients is that we had employers in every industry that was determined to be an essential business immediately responding in March to the pandemic. And certain actions were taken, workplaces were reconfigured, sick leave was changed, some very dramatic changes were put in place immediately. But, you know, what we have to now as employers think about is how do we move into the next phase where COVID is here to stay. We have to have changes and fixes in the workplace that are sustainable. You know, it's one thing to kind of quickly move and expect that, okay, for the next 2 months, I can rotate my shifts this way and it's a pain in the neck, but I can do that. But that's 2 months is very different from 2 years. So what I want to encourage us to talk about and you all to focus on is changes that can be made in the workplace that are quasi-permanent and that can be sustainable. So that's sort of maybe one of the most important things that I can share based on, you know, the work that we've done and the interaction we've had with OSHA and where I think the agency is going. And, you know, speaking of that, I guess I just want to also say again, by way of background, that right now we're operating in the time of COVID and also the time of the Trump administration. And I think we have a pretty good handle on where federal OSHA is going to be until at least the end of this year in January. However, the one note that I want to make sure to make is that if in fact in November there's a change of administrations and Joe Biden is elected president, what that will mean for COVID, I think, in as early as late January, early February 2021, is a real sea change at the federal level. So what we're dealing with and seeing now is not necessarily predictive of what we will see in 2021. It depends on what happens on that fateful day of November 4th or 3rd of this coming year. So, you know, note to self, check again on November 5th to see, you know, what the world and the landscape in the world of COVID and occupational safety and illness arena looks like. And we're, again, you know, we're happy to regroup then if you'd like. But right now, where we are is this. We have a federal agency that I think Nick and I have a pretty good handle on in terms of what is required legally. Now, you know, there's what's required legally and then best practices. And so, you know, you all may be somewhere in the middle, but I want you to at least understand sort of bare basics. And with regard to that, also I know many of you are health and safety professionals, COVID is very different because you guys typically, I think, as we are, as OSHA counsel and MSHA lawyers, we're used to thinking and believing that what federal OSHA does essentially is what we have to deal with. We've got some states on the West Coast, California, Washington, Oregon, that kind of go their own way. But other than that, even with the rest of the state plan states in America, for the most part, what is done on the federal level is mimicked on the state level. That is not at all what we're dealing with COVID. State plans, we're seeing signs that state plans are going their own way. And that is critically important to understand. We'll talk a little bit about that. But even beyond that, what is, I think, most important to understand is even if you have a handle on what federal OSHA requires and or what the state plan OSHA requires, you also have to deal with, for every single workplace, the myriad of local, city ordinances, county orders from the Department of Health and state Department of Health orders and the governor's orders and proclamations that have been issued. And I'm telling you, it is a crazy web. You may all know this already, but it is a crazy web of sometimes conflicting requirements and certainly this web of complete confusion and lack of clarity. I was just yesterday dealing with a client who had everything in line, had an exposure control plan. We worked with them, all good. And, we learned that their county, in fact, they have facilities kind of across the nation. There were 7 counties in which they were operating where the state Department of Health issued orders that said that you had to report as an employer to the county health department within a certain amount of time if you have a COVID cluster in your workplace, defined as, different counties did different numbers, but typically 3 or more COVID case confirmed positives in your workplace. You had an obligation to report to the county health department. Now that is something that would be foreign to any of you who work in the OSHA world. There are certain reporting requirements, but those are for hospitalizations or fatalities. So this is different, but certainly a legal obligation. So anyway, I don't mean to scare anyone, but I do want to, as OSHA lawyers, we want to share with you that there's this is a landmine that you've got to navigate. And obviously, post this call, Nick and I are always here, like I said, almost 24/7 and the task force that our law firm has put together to help walk through that thicket if you need to deal with specific circumstances. Okay, well, I think I've kind of monopolized enough of our time. We've got some sort of key topics, but I want to first, sort of turn it over to Nick to add, supplement, say whatever you'd like, Nick, and then Scott, you direct us whether we should sort of keep talking about big picture stuff or open it up to the audience.
Yeah, that sounds great, Kate. Thank you for starting us off, and it's my pleasure to be here today with you too. I think the big takeaway is, as Kate said, we've been living and breathing this for the last 4 months. So there's a lot of specifics out there. There's a lot of information. We're happy to discuss anything with anyone at any time. But some of the really important items that have come up and that have led to a lot of questions from our clients, and that we've helped kind of through this process of working with a lot of these essential employers develop through that, are the obligations that we have to do to take for protecting the workforce when they actually do come back to work, if we are someone that was shut down and now we're returning to work, or if you are similarly situated as essential business, these steps that have evolved as best practices and really, in some cases, in the eyes of regulators, maybe not required, but expected. And, if we don't have those, even if we have been operating for the last 4 months as an essential business, we need to really start getting them in line at this point if we haven't already. Because as Kate mentioned, this is not going to change anytime soon. And if, again, U.S. and the November election, there is a change of administration, it could get much more stringent with terms of enforcement by the regulators. So, one of those big overarching items is your exposure control and response plans. Every company should have one at this point in time. These are going to really outline everything that would happen if there's a response, whether there's a COVID positive employee on the work site, or as Kate mentioned, a cluster. You want to be tailoring these to your specific site so that you are taking into account what your state or local governments, whether it's a municipality or a county, are looking at, and what their expectations are. Because, as Kate was just describing, totally separate from what your federal or state obligations might be are these new local ordinances. And they also are going to be obligations that an employer has to meet per their specific work sites. So you want to look at this, and you really want to build out this documented plan. It should be something similar to you see for a lockout tagout program or a HAZCOM program. It needs that level of detail, and possibly even greater. It's going to help with minimizing both the employee risk, because we will develop these policies and implement them at the work site. Things like health screenings or mandated face coverings, or even documenting what our expectations are if there are sick leave questions. But we also want to do this from an employment risk side, or from a risk side in terms of regulatory compliance. OSHA has been very busy and are getting busier with complaints on COVID-19 in the workplace. And they are starting to get back into their, I don't want to say a normal, but a more normal-ish inspection posture, depending on what the cases are doing in that specific geography. If you're part of the country where we're having these spikes or these increases in COVID cases, OSHA might still be reluctant to come into the workplace, but that doesn't mean they're not going to send letters and request information and request responses with what you're doing as an employer to protect the workforce. And really, one of the best tools that you can have, and best defenses, is having a robust and complete exposure control and response plan. And I think which goes all of that, implementing it in the work sites. If you have that, you're probably going to have an answer, and a probably good answer, to most of these inquiries as to what you are doing to protect your workforce. So you want to look at that. Again, some of the areas where you really see a lot of questions come up is with health screenings. Are you doing symptom checks, which might be mandated based on your local and state jurisdiction? Yeah, go ahead, Kate.
Just one, before you move off exposure control plans to health screening, let me just add one thing and reiterate what Nick's saying. One of the things I wanted to share with you guys is, as regulatory lawyers, we speak in acronym. And if you remember two things from this webinar or this roundtable, the two acronyms I would suggest you remember are ECP and ETS, okay? And we'll talk about ETS later, but ECP is this exposure control plan. And Nick got it. I mean, what Nick said is exactly right. The two sort of main reasons that you should have one are, one, because you really do need to think thoughtfully and comprehensively about how you are dealing with prevention of COVID in the workplace. And there's no better way to do that than to pull it all together. And I'm sure you guys have all done, reconfigured your workplaces or implemented administrative controls, PPE, new hygiene practices, a whole slew of stuff. But pulling it all together into one document is going to help you, because you're going to see any gaps, and you're going to be able to do a better job in your controlling of exposures. Dealing with, as Nick said, when you do have a COVID, but hopefully using it to keep COVID out. So that's, as Nick said, one of the reasons to do it. Second is employer liability. It insulates you from liability under OSHA's general duty clause. Even though it is not a requirement, it is just a recommendation. OSHA has, as I'm sure many of you know, this umbrella general duty clause that they can use to enforce where there is a recognized hazard and a feasible means of abatement. And the best way you have to show OSHA, if you get in the crosshairs about whether you've done enough on COVID, that you are not liable under the general duty clause, is to have this nice written comprehensive ECP. Third and final reason, or maybe there are more, but third important reason, critically important to my mind, for having one of these is, I can't tell you, I mean, these are real lessons learned. We've seen in real life how having something like this helps the anxiety level of your employees. We are dealing with a completely unprecedented situation. And I have got massive amount of sympathy and empathy and, alignment with the workers who are scared. They're essential businesses. You're asking them to work in their workplaces. You're doing your best to protect them, but my God, this isn't even a hazard you created. How do you know for sure you're controlling it? You don't, because the way it's transmitted. So they're scared and there's a lot of anxiety, and having this has actually helped employers use it as an effective communication tool to show their employees, listen, we are doing everything that, CDC has recommended this, that we have all these recommendations, this is how we've implemented it. And it does lower the anxiety level. And that has two benefits. One, your workers are happier, less scared, and better workers. And just, as an employer, if you care about your workforce, which I'm sure you do, that's a good thing. And second, you're less likely to get the proverbial, employee dropping a dime to the local either health department or OSHA authority because they're scared, which, we've dealt with, it feels like, I don't know, there have been approximately 35,000 notices of alleged hazards, which starts an investigation of employers over the last few months on COVID. I feel like between Nick and I, we've dealt with about 33,000 of those. I'm sure that's not right. It's probably only been about 200, but it sure feels like I'm doing that every single day. And we will lower the number of employees calling complaints in that their workplace is not sufficiently protected if we share with the employee a really good tool that we've got. So that's a third and final reason to do it. And sorry to interrupt, but I wanted to emphasize that. And Nick, back to you and health screenings, if you'd like to talk about that topic. Although I want to turn to Scott and ask you, is this okay, Scott, or should we, how would you like to proceed?
Yeah, no, this is great. And I apologize. I think I missed on the intro. If anyone has any questions, you can post them in the comments area. So if you're on Zoom, down at the bottom there's a chat button that'll open up a comments field. You can post your questions in there. Once Nick has a chance to go through, you can also, I believe there's a raise your hand button if you'd like to ask the question in person. Tamara and I will do our best to get to that. And if you're on Facebook Live, you can post your question in those comments, and we're moderating that as well. So we'll get those questions to Nick and Kathryn. So thanks, Kathryn, for letting me.
Sure.
Yeah, and I think those were all good points, and we do welcome all your questions. And I think Caitlin both can tell you that we could sit here and have this discussion and essentially just be her and I going for hours, and have done that, and we probably will continue to do that as this goes on. So I don't want to belabor too many of the points and go over this. We provided some resources, Safepedia, that we've given them permission and hope they are and know they're going to share them with you. Whether it has to go to your reporting requirements with OSHA during COVID. Additionally, we provided links to the resources that our firm has compiled and put together throughout this in our COVID-19 Resource Task Force page. And in there, you're going to find detailed breakdowns of and blog posts and webinars that are going to go over what are required and what are your obligations and what are your rights with respect to holding health screenings prior to individuals coming on the work site or doing symptom checks. Also, it's going to look at what is the difference between PPE and cloth or mask or facial coverings, and what are the differences, what are your obligations with regard to providing those, what are your obligations or your rights with respect to require them in the workplace. These are all important aspects. I think we are seeing, some division around the country, both politically and from experts, on the importance of masks. But I think just recently the CDC came through and said that everyone should be wearing masks, and that would certainly help expedite the resolution, or at least help with control of COVID-19 and the spread of it. So, that doesn't have to be an N95 respirator, doesn't have to be a respirator of any kind. And there's a lot of guidance out there, and we've written a lot and posted a lot and done a lot of blogs and webinars just on your PPE requirements and the differences between that and facial coverings. So, those resources are out there. And, I think Scott just said that he's going to be posting this recording, and he's going to be posting all the materials that we provided to them. So I encourage you all to look at those. But I think part of what today's goal is to have a bit of an open discussion and an outlet for you to ask some questions that Kate and I would do our best to answer in real time. And if we don't have an answer for you right now, we'll be happy to follow up with you and get you the answer that you need. So Kate, I think with that, we're about halfway through what was the schedule allotted for the presentation or the discussion today. Is there anything else you'd like to add, or do we want to turn it over to start doing some questions at this time?
Yeah, I mean, if there are questions, everyone, guys and gals, we would love to, start talking about the specifics that you're most interested in. And if no one has any, then, maybe we will dig down at least one more level on some of the key topics that we get questions on all the time, like Nick said, with health screenings and face coverings would be two to cover, and sick leave. And I'm not sure I know, by the way, if anyone has a question, I'm not sure, Nick, I'm gonna let you tell me that, because I don't know if I have that box open.
I think Scott's gonna relay them to us, or Tamara.
Okay.
Yeah.
Gotcha.
Yeah, so Chris was just asking, you mentioned the two top takeaways, the ECP and the ETS. People are just requesting a little clarity on the ETS.
Gotcha. Okay, good point. Good question, Chris. All right, so ETS stands for Emergency Temporary Standard. If you all have been tracking this, you would know that OSHA was requested by labor organizations. I can't remember, AFL-CIO, I think, was part of it, and I can't remember who all else, but a number of entities joined together and petitioned OSHA, federal OSHA, to immediately establish an emergency temporary standard that deals with infectious disease control in the workplace. About, 6 weeks ago or so, maybe 2 months ago, OSHA fairly promptly denied that petition, said they did not believe it was necessary to do a new standard, a new rule, because their existing standards and/or the guidance that they have issued since COVID cover what is necessary for employers to do in their workplaces. As a result of that denial, two important things happened. One, the group sued the agency, I think in the DC Circuit Court, to require the courts require an emergency temporary standard to be established. The DC Circuit Court ruled very quickly and rejected that challenge. So we were left on the federal level with no emergency temporary standard. So the next sort of consequence of that is a number of states have started scrambling to develop, and it's called an emergency temporary standard for a reason. It's because it's like, it happens in the OSHA regulatory world, like lightning speed overnight, meaning in a couple of months time, as opposed to sort of on average 15 years that it takes the agency to promulgate a non-COVID, non-emergency temporary standard. So right now we've got all the West Coast entirely, Washington, Oregon, California, indicating and at various stages of the development of emergency temporary standards. California, by the way, already had pre-COVID a non-aerosolized and aerosolized infectious disease control requirement standard. And, it's fairly complicated. And I suspect California's new rulemaking, to the extent they actually go forward with it, will look a lot like that, maybe fill some gaps. Virginia, just yesterday, and this is a real surprise, just yesterday, finalized and promulgated an emergency temporary standard. So if you guys are advising in the states or have have facilities and or advising companies in the state of Virginia, there's now a new standard. Okay. And then there are a number of other states that have this in the works. So many states, and you will see predominantly Democratic gubernatorial offices that are moving forward, or if there's a Democratic legislature or governor's office, and certainly where there's both, there's a movement in this direction. Less so in the Republican-controlled states. The emergency temporary standard, the reassuring news as someone who might have to implement that standard, is so far what we're seeing, California may be different, so far what we're seeing is a fairly performance-oriented approach where it is not sort of a command and control, like the guardrail standard. You have to have 28.7 inches no more between the guards, the rails, and blah blah blah. Sorry, watch that, but you get my point, right? It's not telling you, okay, you have to have social distancing by moving your equipment, this many feet apart, and you have to have hygiene practices whereby you install 37 new, or I guess the way they do it is a new portable sanitizing machine for every 15 employees you have, and you have to give employees 3 breaks a day, to per shift to go wash their hands, and those breaks have to be 10 minutes apart, whatever. They're not doing that. They're saying you have to social distance. It has to be 6 feet apart. Keep your workers there. If you can't, you have to have face coverings. You have to have hygiene practices, et cetera, et cetera. All the engineering controls, administrative controls, PPE, generally, but not specifics. Your job as the employer, though, or someone advising employers, is going to be to put the meat on the bones of how you comply with that standard. And one of the ways you do it, by the way, is through that ECP that we talked about. So that's what an ETS is. It basically takes all the regulatory guidance and recommendations that have been issued by the WHO, by the CDC, by the state agencies, and it mandates that you do these, but it's a very high-level, performance-oriented mandate. So that's the ETS.
An interesting add-on to that is, it started off by describing when there was a labor challenge and they actually sued OSHA in the DC circuit. And despite the result there, OSHA's sister agency in the Department of Labor is experiencing the exact same approach by labor organizations right now. And a couple of the mining labor associations, the United Steelworkers and the United Mine Workers, have sued MSHA, or the Mine Safety and Health Administration, in the same court, trying to get a emergency temporary standard implemented by the Mine Safety and Health Administration. So similar to OSHA, they are obviously fighting that and believe the existing regulations allow them to adequately protect the workforce. But we're seeing it, I guess, again, it goes to the fact that we're seeing it on multiple fronts. You'd think maybe one labor challenge to the Department of Labor would have sufficed, but the sister agency is getting the same treatment as we speak. And the DC Circuit has not ruled on that petition at this point.
Good. Well, we've got a few more questions rolling in here. So Conrad's asking, regarding face covers, if an employee is providing masks, but employees choose to bring or wear their own, fashion or personalized face covering, should an employer, allow that? And then I guess, do we know if there are any, inherent risks with allowing people to wear their own protective face coverings?
So funny you should ask, but we have a slide, I think, that might deal exactly with that. I think might be in the slide deck that we sent you, slide 18, but we might have changed the number. So take a look when you get this slide deck. There are about 4 or 5 slides in here that deal with this general issue of face coverings. And let me, and then I would love Nick to supplement and add in, but let me just sort of give you some important things related to face coverings, and then answer this question specifically from Conrad. So this may be something you all know. As Nick, I think, alluded to or mentioned earlier, face coverings are different than face masks. And I try really hard and I fail a lot, but I try to use the terminology that makes that clear. I try not to call the things that I walk around with every day, the paper masks or the cloth masks. I try not to call them masks. I try to call them coverings. So the paper covering or the cloth covering, facial covering is what many people are wanting to bring into the workplace. Or at least the cloth covering, because they have their own designs and that kind of thing. So one, I want you all to know that's not considered PPE, okay? PPE is designed to protect the wearer. These face coverings, although they do protect the wearer, they are designed predominantly to protect those who the wearer is in contact with. My mask, my covering protects you, your covering protects me, right? So, and there is no guarantee that a face covering made of cloth or paper is going to actually prevent COVID respiratory particles from invading your respiratory system. So it is not PPE, and therefore you are not covered under 1910-132, OSHA's PPE standard, nor is it respiratory protection, and therefore you are not covered under 1910-134. Regarding individuals bringing their own mask in, the question that I think you guys raised, we think that, you know, it's not PPE, it's allowed. You're not required anyway to pay for it. So you certainly should let someone bring in their face covering. It's not like you have a certain standard of protectiveness that you have to meet and you don't know if theirs does, so you better be careful. That's not the situation we're in, like you would be with regular, like, you know, a respiratory protection, where you wouldn't want the worker to just bring in his own PAPR or, you know, N95 or whatever. So yes, we think it's a good idea to allow workers to do that. We also think it's a good idea to at least give some basic sort of training, and I'm not talking extensive or anything that would cost a lot of money, but I do think it would be important for your workers to understand the basic concept that I don't think most of America does understand, which is my covering protects you, your covering protects me. I think more people would be wearing masks if they were, because I think people are decent people, and I think people have this libertarian sense that, you know, I'm not going to wear a mask, some people, but that's their choice. They get to make that choice, but their mask isn't designed about them. It's designed about all the people who around them who might want to be protected. So I think encouraging that education in the workplace is a good thing. And also sort of the flip side of the coin of, should you let someone bring their mask in? Yes. I think two other things. One, even though it's not PPE, you're not required to give it out. You're not required to pay for it. I would encourage employers to have some on hand to provide your employees who don't bring in their own, because you want to protect your workforce, and it's cheap stuff if you can get it. I'm not talking N95s. I'm talking, you know, non-FDA approved surgical masks, the things you can buy, like, you know, a stack of 200 for $10 or whatever. So I would encourage having that on site. What if and second, you know, many employers are going to a mandated policy. You cannot be in the workplace without a covering. If you go there, and I'm very, you know, encouraging our employers to do that. If you go there, two things. One, that increases, to my mind, your, you know, responsibility to have some on hand, not because of the work or because of your situation. Do you really want to require people to have them? They show up without their homemade, you know, UVA banner or whatever. And what are you going to do? Send them home or let them violate your policy? I mean, that's not good for you. It's going to waste time. You're going to have to get another employee to cover the shift, et cetera. So I would encourage you to have them, especially if you mandate it. And I would encourage you to mandate it. And then finally, I wanted to share with you that if a worker says, no, I'm not wearing it, you know, whatever, it's your workplace. Even though it's not PPE, you get to set the standard. You can say no short shorts at your workplace. You get to set the work dress code. You get to say, you know, whatever you want, essentially. So you get to say that, as long as, with the caveat that, and this kind of moves into the employment law, if someone has and OSHA, if someone has a medical condition, a health risk associated with wearing it, then it would be a violation of the ADA to require it. And or if someone has a good faith, sincere religious belief that would be contrary to wearing masks, then that also would be something that you need to accommodate. Shy of those reasons, though, you're free to mandate it. You're free to require them to bring their own, but you should have some on hand.
I think another part of that, though, you know, is you mentioned briefly the training, right? Why are we wearing masks? And there are some recommendations out there as to what these face coverings or cloth face coverings should really have, or the features that they should have, and those come down from the CDC. And so while there's a wide range of materials or coverings that would satisfy these, you know, they should fit snugly, but be comfortable. They should be able to be secured with ear loops or ties. They should be multiple layers, because again, it is trying to stop the spread of particulates that are coming out of you when you're talking or when you're breathing or coughing or sneezing or whatever it may be. You also want them to be breathable without restriction. So you don't want them to be so dense and so many layers that it actually makes it more difficult for people to breathe, because then you're essentially getting into that world of PPE and the risks associated with, you know, respirators as they control the airflow. And so you want to avoid that. And then lastly, you want something that is easily can be laundered or dried out or cleaned without totally damaging it. And you want that to be known that it needs to be cleaned and laundered on a regular basis, probably after each use. You know, I think that probably should be a certainty, but, you know, you want to educate the workforce, not just on, you know, these different options, but what entails a good mask, or what entails a decent face covering for the purposes of have something that is actually going to fit and do what it was intended to do. So, you know, those are some of those items. If you have people who are trying to come in with their own N95 respirators or want to wear those, as Kate mentioned, that brings in a lot of questions regarding PPE. You know, are you going to be providing them with Appendix D of the respiratory protection standard because they are voluntarily wearing it? Or if you're mandating they wear those, you know, again, that's going to be triggering all the requirements in respiratory protection programs and associated regulations. So, you know, looking at that and looking at what's required from your states and your local governments, because they might have requirements about wearing masks in the workplace, in addition to what yours are. You know, you need to be cognizant of all those, but you also want to provide a lot, you know, education and training to your workforce about the importance of maintaining those, of cleaning them, and if you are letting them bring in their own masks, what are some minimum standards, or at least some minimum recommendations for what is, or what may be an effective face covering.
Great conversation. Love it. We have a few people on Facebook also joining us, and Pang has asked a question. Is there an OSHA classification risk of worker exposure to COVID-19?
OSHA classification risk. I'm not sure I totally understand the question. Let me see if I do and answer it, and then you tell me if I'm not talking about, you know, I'm up the wrong tree. So when the pandemic first hit the United States, one of the first things that happened was OSHA issued, I think it was on March 9th, it's in your slide deck at page 5, this official guidance on preparing workplaces for COVID-19. It was one of, you know, now a myriad of guidance documents that have been issued. And it largely follows the CDC guidance that had been issued. And that OSHA guidance, along with the CDC guidance, did in fact develop categories of risk for workplaces and job tasks from very high, medium, high, and low. So there are 4 categories, and essentially, rough cut, the very high and high are basically healthcare and death care workers, as well as, and jobs, as well as the sort of penumbra and ancillary jobs associated with that, like first responders. And then the medium and lower are those industries that have work tasks that require their workers to not be basically in close contact with a potential COVID person, and not in contact with the general public, like someone in a grocery store that deals with every day the general public coming in close contact. So even though it's not healthcare or death care, you've got general contact, many general contacts a day. So yeah, so those are the categories, rough cut.
Thank you.
Yeah, thank you. We'll see if Pam comes back with a further question. But one, just interesting, as you were talking about the face coverings versus masks versus PPE. Kalish asked if, in respect to disposal of PPE in particular in industrial environments with COVID out in the wild, are those the disposable PPE considered biological waste, and do they need to be treated differently again when disposing of them?
Good, really super question, and one that we got about a month ago. I want to say, I'm going to ask Nick if he knows anything further on this. I want to say I am 90 to 95% certain we know the answer to that, and the answer is no. That the regulatory agencies have determined that the COVID waste is not considered a waste that has to be treated as a hazardous waste and or a biological waste. But I do have about a 5 to 7% uncertainty in here as to whether I got that right. So Nick, do you know? Certainly we can get back to you guys because it has been answered. I just can't quite remember.
That's my understanding as well, but I think it's one of those things that maybe we each have enough doubt that we should follow up and get back to everyone with a firm answer on it.
Yep. Yeah. And I think, as I think this through, the reason I believe that's the case is because although COVID, as you guys know, probably from just general knowledge, COVID does last on surfaces for some short a period of time, depending on the surface. But even every surface that's been studied so far, the amount of time it lasts is, days or hours, not months or years. So to treat waste as a biohazard or hazardous waste that has to be dealt with through RCRA or whatever would be manifestly burdensome for something that is going to lose any concern within probably hours.
It'd be great if we could invite you to our Safety Movement Maker Facebook group, Kathryn and Nick, and maybe post the reply to that on that group if that works for you.
Sure.
Certainly.
Sure, we will do that, right, Nick?
Yeah. We'll figure it out. Yep.
Okay. Thank you.
So Laurie was asking a question: is there a list or a way to obtain the updates on the states issued ETS?
Really, no. I mean, yes, call us and we will figure it out for you, but or call someone.
Follow our blogs. I think we'll probably be posting on them all as they come through.
Right.
Yeah, good point. Good point. Nick is a big blogger. My partners are big bloggers, and we tend to, sort of update that. Virginia just happened yesterday, but I just want to make sure there isn't, that I'm aware of, and I would really like this resource if it existed. There isn't a place that I can go or you can go and say, oh, okay, here's the 50 states and here's where they are on the various steps they've taken towards an ETS. I can tell you that Virginia is the only one that has finalized it as of yesterday. But do remember, California already had one that wasn't COVID related. It was just infectious disease related on the books. Also, FYI, just a point of interest, if you know, if this is interesting to you, OSHA was in the process of developing an infectious disease standard in the, you know, late 2005 to 2014 time period, nothing to do with COVID, just general infectious diseases. And it was put on hold and they didn't move it. And it was because the agency prioritized something else, and I'm kind of forgetting what that was now, but they went forward this other thing and not the infectious disease standard. You know, hindsight's 2020, but I think some of them are, you know, sort of ruining the day that they made that decision. But there is something, the reason it's interesting is OSHA already has a platform. They've already done some site visits. They already did, you know, they moved through the regulatory rulemaking process to a certain point. I think they even did a SBREFA with the Small Business Administration, putting out at least what a preliminary standard would look like. So if you're interested and you expect that Joe Biden is going to win, and therefore you expect that by February, the agency's going to turn course and say, we're going to do an ETS, it's already sort of existing in rudimentary form anyway. And that's all available publicly online.
Right. Yeah, and I should mention, I touched on, we've got the private Facebook group, Safety Movement Makers, where again, you can continue to post questions afterwards and we'll do our best to answer them. The material that Nick and Kathryn have provided will have their contact information. So definitely, if you're unsure, you can certainly reach out to them after the fact to get specific answers to your questions and describe your situation in detail for them. So that will be available to you as well. So Crystal has a question. The Georgia governor just issued an order stating that local municipalities and cities can't require face coverings for public spaces. And she's just wondering, does that affect entities that are funded by government grants? She's just wondering if it extends beyond places like government buildings or parks.
I do not know. I don't know. It's a really good question. And I think unless, you know, in order to avoid demonstrating my view of the situation in that order, I should probably shut up right now. Nick, any thoughts on, you know, the scope of that new order from Governor Kemp?
I think you have to look at what it comes down to in terms of public places or public spaces. And typically that does not apply to places of employment or workplaces, which are controlled. You know, I think the question of government funding or government grants, that puts a unique aspect into it. But you know, again, I think Kate and I are both pretty biased in this. We've been working on it for so long. We think that face coverings and masks should absolutely be worn in any setting where you are not isolated or physically and socially distanced at least 6 feet from other persons. So that most certainly, I think, should apply to workplaces. So I also don't have a firm answer for you, or maybe an exact answer, but I would say that if you're looking at public spaces, typically employers are not considered public spaces when you're in the workplace. And you would have more control.
Yeah, I mean, I think at least we can say that, like, the general private employer, no. But I mean, it's a great question, because I think one of my children goes to a state school here in Virginia, and, you know, I'm wondering, if not that Virginia would do that, but, you know, if it's Georgia State or whatever, you know, public university is there, does that apply to the university? I mean, that would be, you know, that'd be something. Anyway.
Yeah. So Chris has got a question. The mayor of the city that he's in, Austin, Texas, set out an order determining that body temperature required to enter a business is at 99.6 degrees, where the CDC recommends 100.4. And he's wondering which one should he should be considering to use in terms of you know, protecting the company from litigation or issues that may arise.
Gosh, I mean, this is just so perfect an example of this impossible web of requirements. I mean, so it was Austin City Ordinance, did you say that?
Yeah, it was the mayor of Austin set out the order determining that it should be 99.6, where the CDC is recommending 100.4.
Right, right. And I assume, I missed the fellow who asked the question.
It was Chris.
Chris, I assume Chris is thinking about some workplace in Austin?
Yes, I believe that's
Yeah.
that's where the question is coming from. So, and just and you know, I had a question kind of that fits into that earlier, and you guys may have addressed it, but like OSHA, I mean, don't need to go into too much, you know, history and background, but they're typically, you know, out there checking compliance and finding companies that are not compliant with their guidelines. So how are they approaching it? Like you said, this is a really complicated web that we're in right now, and there's obviously OSHA standards that may deviate from state or municipal standards. Are they applying whatever's in place locally when they go out and do their investigations, or are they just looking at the OSHA standards that they have set? And I'm not sure if you addressed that or not.
Okay, so two really good questions. On the question, Chris, related to the distinction between 99.6 and 100.4, you know, I guess the way I'd answer it is this: to be prudent, I think if there's a ordinance, I just tried to Google it, I couldn't find it that quickly, but I'll look at it. We'll look at it. If there's an ordinance that says that, you know, 99.6 is the standard, you know, I mean, you don't need a lawyer to say the prudent thing would be to set your screening at that level. However, I also want to rush to say that the CDC has not changed the guidance from the get-go. It's always been 100.4. That's what OSHA has adopted in guidance. So I think if OSHA were to come in, and Texas is a federal state, it's not a state plan state, I think. If OSHA were to come in, I think, you know, if you asked us, if you had an enforcement action and you asked us to defend you, I would think I'd feel pretty solid about my defense of that citation based on the existing guidance from CDC. So, you know, okay, so that's the legal question. Health-wise, I don't know. I mean, it's crazy. We don't know. We don't know. I have no idea where the 99.6 comes from. I know that the 100.4, there are some studies that OSHA, I mean, that CDC and WHO had that I think were the origin of that 100.4. But I don't know what is the right one health-wise. So I'm sorry. It's a mess.
It also might be worth looking into to see if that Austin City ordinance is a recommendation, or is that actually something enforceable by the Department of Health? That might help you make that determination. Is that something that they can come into your workplace and say you're measuring to 100.6 or 100.4, I'm sorry, instead of 99.6, and therefore the health department can shut you down or something of those? It's something that you want to consider. And again, as Kate said so many times, this is one of those, you know, chicken and an egg, or, you know, or catch-22 situations, whatever you want to say. There's so many different guidance, so many different recommendations going along. A lot of times you have to look at which one, if any, has teeth, and maybe that can help steer you in the direction that you need to go. Because, you know, as we've said, there is not a standard from OSHA on this. You know, we're following recommendations and guidelines, and some of these local ordinances can be enforceable in their own way.
Yeah, good point. Really good point. And then just to address the broader question very quickly, Scott, typically what OSHA is doing right now is they are relying on the guidance that they have issued or CDC has issued, as opposed to the more restrictive state guidance when they come in to do an information request or a pre-enforcement action or investigation. Again, that may change. In fact, I would suspect that would change if there's a change in administrations. But right now, at least you can take some solace in the fact that if you have adopted policies, protocols, programs that are consistent with what OSHA has issued as guidance, then you should be safe from an enforcement standpoint from OSHA. But with the point that Nick made, if there's some local ordinance that is mandated, obviously on a local level, you could be, fined or whatever. But OSHA has not been sort of deeping down, pulling that up and using that as the standard to enforce.
Okay.
Yeah.
So, oops, we're on the hour. We still have a number of questions to get to, and there's a number. There may be still some coming in. I know Kathryn and Nick had graciously offered to stay on longer if people would like to hang around and continue to ask questions. But I did just want to draw to everybody's attention. We're on the hour. If you've got other meetings and things to get to, we will be posting again this video in our private Facebook group, so you can always go back, watch it later and get the answers to some of these questions. But with that, they're coming in fast and furious now, Kate, so let me just bear with me for a second here. So yeah, Conrad is asking, how would a medical condition need to be documented if an employee states they can't wear a face covering due to medical conditions? And does the employee need to provide a doctor's note?
Okay, so I did see that pop up at one point, Conrad. I want to caveat this to just let you know that my area of expertise is the occupational safety and health sort of side. My partner, Carey Maciel, and her team is the employment side. This is kind of crossed over into the employment side, but we've been working really closely together on COVID stuff in particular. And what I believe is the case is under Title VII and the ADA, what is required is a dialogue with, if the employee raises an issue that is based on a disability, they can't wear it because of a disability, then what is required is an accommodation of that disability, unless you cannot do so and protect your workforce and your employee. So what has to happen under the law, under the ADA, is there has to be dialogue back and forth between you and the employer and the employee to see if they can reach some accommodation where the employee's medical situation is sufficiently addressed and you can still protect your workplace. As to what you could require, you can ask for a doctor's note, essentially, determination that yes, this person cannot wear a face mask because it would cause respiratory issues or whatever. I want to get back to you. I'll check with Kara and we'll get Scott the information and Tamara as to whether you're allowed to mandate that. That is to, it's for sure you can ask for it and should, I think. But can you say, well, unless you produce this to me, I'm not going to accommodate that. I'm not sure you can go that far. So let me check on that. In fact, I'm going to check right now while we're talking and maybe have an answer for you quickly.
Yeah, and I think this question may have been addressed. Terry may have posted it during the answer, but just Terry's saying that if the city has issued the temperature at 99.6, would that be considered going above the required standard as we're told in OSHA clarifications?
Yeah, I mean, it's going above and beyond what is required. Now, one thing to know is that there's no prohibition on that. Even like an OSHA state plan, if it were in, let's say, California, and California OSHA decided, well, federal OSHA said 100.4, but we want to be even safer, so we're going to mandate a standard that you have to test at 99.6. That's allowed because the states can always establish standards that are more stringent than federal OSHA. They just can't be less stringent than federal OSHA. So they can do that. Whether it's a good practice, whether it's a good idea, I don't know, because I don't know whether 99.6 would ferret out more COVID cases than 100.4, and or whether it would actually pull in some non-COVID cases that you wouldn't get with the 100.4, which you wouldn't want to do. You don't want to pull in the flu people. It's
Right.
a bad enough situation with just identifying the COVID. You don't want to create a worse situation by mixing in people who have a slight cold or flu.
Right. And
Likewise, companies can also choose to be more restrictive or more stringent than what is recommended by the regulator. There's a lot of questions about why you might want to do that and why not. Like Kate said, you don't want to bring in cases that might not be, but temperatures aside, just remember that typically the regulations are a base. That's what we need to do to comply as companies, and many companies have been throughout this process, really being the driver in implementing kind of more stringent workplace practices, hopefully consulting so that they are doing so within the bounds of labor and employment and not violating any questions there. But you do have that flexibility and that freedom to go more restrictive in order to protect the workforce. So it's not just you're looking at states versus federal or local governments versus the federal, but those are corporate decisions or company-based decisions that you can make as well.
right. And I should mention, and I touched on it at the introduction, but this is we're hosting this workshop. We're going to have 4 other sessions with industry experts in different areas. So we will have some medical expertise next week. Talking about it from a physician, emergency doctor perspective, and he'll be that's Sam, and he'll be accompanied by Chris, who's a PhD in fluid dynamics and talking about pandemic management. So we will get into the medical aspects in a little more detail at a future workshop. And Rajni Wali from DACRA is the next speaker, and she'll be talking about the mental health aspects of and mindfulness, for employees returning to work, when they may be a little anxious, maybe a little anxiety, and obviously everybody's been cooped up at home. So how do employers help manage that aspect of the return to work? So just to let people know that again, we'll have a few other experts on online to go a little deeper into some of these issues. So we're getting lots of great thank you and kudos, and very informative, and Lori and Paul were glad to attend. We had someone joining us from the UK, Bogdan, I think, and he has quite a bit of information. I won't go into the details. We'll share that definitely in our Facebook group. But just talking about how there are the legal requirements and guidance and actions in place, but the risk assessments rule over all of these as far as reasonable protocols or processes to put it into place. So as employers, we're responsible to take care and do these risk assessments and make sure that we can provide as safe an environment for employees as possible. And I think that's probably universal regardless of which country or which state or which county you're in. So thanks, Bogdan, for that comment.
Scott, could
yes.
I add something?
Yeah.
2 comments that your statements there reflecting the UK fellows comments reminded me of. One is a question that you guys asked me when we first started, Nick and I first started talking to you, related to working at home. you know, as millions and millions of Americans have been now mandated to, either allowed to, encouraged to, or mandated to work at home, telework has taken on an entirely new meaning. And one of the questions that we were asked is, does that mean, from a safety standpoint, a safety and health standpoint, can OSHA mandate that the employer who is mandating its employees to work at home, like Conn, Maciel, Carey, my law firm, is now, you know, there is no office that we, well, now we guess we can go under certain conditions, but none of us are. So does that mean that my employer has to provide a safe and healthy workplace, including my dining room here? And I don't think that applies to housekeeping, or they would be in really bad trouble, because as you can see from behind me, our housekeeping is lacking a little bit here. But seriously, I want to share with you that before COVID, OSHA had been asked this question for just the regular teleworkers, and the agency issued an interpretation letter that indicated that essentially because of employee respect for an employee's privacy, their home, OSHA is not going to take jurisdiction over the home workplace, even if it is a workplace. So what that means is that employers are not responsible for ensuring the safety and health of a worker's in their home environment. Doesn't mean you shouldn't, doesn't mean that's not a best practice. It doesn't mean that there wouldn't be, if you don't provide an ergonomically sound chair and your worker gets neck strain and whatever, that you might not get a workers' comp claim for it. So there's a lot of reasons, to consider doing that. But just from an OSHA standpoint, in terms of enforcement of the 5A general duty clause to keep the workplace free of recognized hazards, that is not a thing right now. Workers' comp is. If Joe Biden is elected president, it may be push the envelope. That's the analogy I was thinking of early. It may be that the Biden OSHA administration attempts to push the envelope on that front with tens of millions of people working at home, right? Should there be a safe workplace for them? That may be a different story next year, but right now the answer is no to that. So I just wanted to share.
I think maybe something that Kate mentioned there briefly, and I won't be long here because I know we're over the allotted time frame, but she mentioned the general duty clause as the likely culprit of where enforcement will come from there. Just so everyone knows what that is. Another one of those acronyms we like to use, typically GDC, but it's this enforcement tool that OSHA can issue a citation when they don't have a specific standard to a hazard that is exposed to or experienced in the workplace. And so that is oftentimes, and in this COVID world, what we're looking at, because there aren't those emergency or temporary standards on the federal front, And so in order for there to be a general duty clause violation, there has to be a hazard that exists in the workplace. I think Kate was just describing, there's some arguments if the workplace is home, and that it probably doesn't extend to there, but in general, just related to your typical operations, there has to be a hazard that exists. The employer or its industry has to recognize the hazard. It's kind of hard to argue with either one of those if we're considering that a hazard may be COVID-19 exposure. It's likely, the hazard is likely to cause death or serious injury, and a feasible means to exist to eliminate or reduce that hazard. So again, that's what we were talking about before with respect to a general duty clause, and where there is likely to be enforcement under or for COVID-19, since there is not that emergency temporary standard. There is not a infectious disease standard, as Kate mentioned earlier, either. So something to keep in mind, this is widespread. Everyone pretty much recognizes it as a hazard in the workplace, regardless of that. This is another reason why you have to or should be looking at having a comprehensive exposure control and response plan, because that is going to go towards what did you do as an employer to take feasible means to eliminate or reduce the hazard in your workplace. So just some kind of final thoughts as another key term in the OSHA world in terms of where it could go an enforcement perspective comes up.
Great, thanks, Nick. Yeah, so I think the questions are starting to taper off here as we're getting just 15 minutes, I guess, past the hour. There's a few people have been asking if they're not on Facebook and don't intend to get onto Facebook, can they get a copy of the information? And just let us know, and Tamara and I will connect with you to make sure you get the information. And again, like I mentioned at the beginning, doing this through our private Facebook group is new to us. We're hoping to be able to connect safety experts, allow for some collaboration and discussion beyond just the presentation. So if you're on Facebook or interested in getting on there and joining the group, please do, Safety Movement Makers, and let us know what you think of the format. Again, questions in there, we'll try to get Kate and Nick to jump in and answer future questions if they come up. And again, their contact information will be available, so you can definitely reach out to either of them or their firm if you've got really specific requirements that you want to dive into. And I'm not sure who it was. Lisa, I think, just mentioned that this was super informative, insightful. Definitely appreciated your guys' time and patience with the questions and thoroughness. But just to draw to the point that it is a moving target at this moment. This is a brand new scenario for all of us to be in the midst of a pandemic. Things are changing daily, weekly, monthly. So so definitely need to be actively engaged to stay informed and keep on top of things. I don't know if you guys have any closing remarks around the presentation or around that comment, but we'll finish off with you guys.
I would just say that, and Kate, I'll let you close this out, but I'll just be brief. But I would just say it is a moving target. That's a very good point, and things are going to continue to develop, continue to evolve, as will our understanding of what we're facing, and as will the expectations of the workforce. So it is incredibly important that we stay up to date, we stay engaged on that, and that we stay proactive. As Kate's mentioned a couple of times, the outcome of the election in the end of the year could very well change the enforcement landscape of how we have to respond to COVID in the workplace or the exposure to it. But, for right now, we still need to be taking those proactive steps to best protect the workforce, because, OSHA compliance isn't the only obligation that we have or that employers have. I guess I would just say, if there's any questions, please do not hesitate to reach out to either one of us. We're continue to work with Scott and Tamara to get any questions that come in, follow up, answered, and responses back to you. Kate?
Ditto. We're here. We're working hard on this. We're trying to help employers protect their workforce, and we wish you the best of luck. Stay safe yourselves in your general, life activities, and please reach out if you need any further assistance.
Yeah, well, thank you so much, Kathryn and Nick, for your time today. We really appreciate it. We're excited to kick off the workshop with the OSHA legal aspects. That's been an extremely hot topic and a moving target, and safety professionals are finding themselves in uncharted territories, responsible for things they probably never imagined that they would be responsible for. So again, thank you so much for your time, and again, just to let everybody else know, this is the first of 5 sessions. So over the next week or so, we'll have 4 more sessions regarding the return to work program and addressing mental health. We've got the medical perspective, we've got the technical controls side of things, and then employee morale and supply chain issues topic as well. So please stay tuned. I believe it'll be the same Zoom link. We'll send emails out again like we did today, and it'll be in the same, streaming live in the Facebook group as well. So look forward to your feedback and look forward to seeing you on our next session. But thanks so much again, Kate and Nick, and everyone else for showing up today.
Thank you all.
Yeah, thanks for having us.
Bye-bye.
Bye-bye.
Bye.